A very warm welcome to everyone. Today, I, Reeya Khanna, a legal intern under LEXIS and Company, am here to explain the case study on Bachchan Singh versus State of Punjab, All India Record 1980. This particular video is the part 2 of the video. In the part 1 or in the previous video, I explained how Supreme Court is the highest judicial authority and how on time and again the Supreme Court has given decisions on death penalty. Further, I explained the constitutionality and procedural reforms given under various case laws by the Supreme Court. For example, in Jagmohan Singh versus Uttar Pradesh, and then further on the case of Rajendra Prasad versus State of UP, and even in Attorney General of India versus Lachma Devi. Then I explained the constitutionality of Section 303 of IPC through Mithu versus State of Punjab. Now, in the end of the previous video, we were talking about rarest of rare cases, where the apex court modified the terminology of rarest of rare case in Bachchan Singh case. Now, I shall be dealing with the rarest of rare doctrine in the case of Machi Singh versus State of Punjab, All India Record 1983. So, in Machi Singh versus State of Punjab, the Supreme Court said, I quote, in order to apply these guidelines inter alia, the following questions may be asked and answered. Number 1, is there something uncommon about the crime which renders sentence of imprisonment for life inadequate and calls for a death sentence? Number 2, are the circumstances of the crime such that there is no alternative but to impose death sentence even after according maximum weightage to the mitigating circumstances which speak in favor of the offenders? The principles laid down by the apex court are reiterated in its latest judgment in Sushil Murmu versus State of Jharkhand, All India Record 2004, in the following words. I quote, in the rarest of rare cases, when the collective conscience of the community is so shocked that it will expect the holders of judicial power center to inflict death penalty, irrespective of their personal opinion, as regards desirability or otherwise of retaining death penalty, death sentence can be awarded. The Supreme Court has also discussed such circumstance in various cases. These circumstances include Number 1, murder committed in an extremely brutal, grotesque, diabolical, revolting, or dastardly manner so as to arouse intense and extreme indignation of the community. Number 2, murder for a motive which evinces total depravity and meanness. Number 3, murder of a scheduled caste or scheduled tribe arousing social wrath not for personal reasons, bride burning, or dowry death. Number 4, murderer in a dominating position of trust or in course of betrayal of the motherland, where it is number 5, where it is enormous in proportion. Number 6, victim, innocent child, helpless woman, old or infirm person, public figure generally loved and respected by the community. If upon taking an overall view of all the circumstances and taking into account the answers to the question posed by way of test of rarest of rare cases, the circumstances of the case are such that death penalty is warranted, then the court would proceed to do so. Now, we shall talk about Bachchan Singh versus State of Punjab. The citation of this particular case is All India Record 1980. The judges who gave the particular judgment are Chief Justice V.Y. Chandrachud and Justice A.C. Gupta, N.L. Untwalia, Justice P.N. Bhagwati, and Justice R.S. Sarkaria. The date of this decision was 9/5/1980. The brief facts of this particular case are that Bachchan Singh, the appellant in this case, was tried and convicted and also sentenced by the Sessions Judge to death under Section 302 of the IPC 1860 for the murder of Tesa Singh, Durgabai, and Viranbai. The Honorable High Court confirmed his death sentence and dismissed his appeal. He appealed to the Supreme Court by special leave petition. A bench of Supreme Court consisting of Justice Sarkaria and Kailasam heard the appeal and directed the records of the case to be submitted to the Honorable Chief Justice for constituting a larger bench to resolve the question of constitutional validity of death penalty for murder provided in section 302 of the Indian Penal Code 1860 and sentencing procedure embodiment in section 3 of section in subsection 3 of section 354 of the Code of Criminal Procedure 1973. The judgment given by the honorable judges was the challenge to the constitutionality of the impugned provisions contained in section 302 of IPC and section 354 clause 3 of CRPC is valid. There are numerous other circumstances justifying the passing of the lighter sentence, as there are countervailing circumstances of aggravation. All such situations cannot obviously feed into judicial computer since they are astrologically imponderables in an imperfect and undulating society. A real and abiding concern for the dignity of human life postulates resistance to taking a life through law instrumentally. That ought not to be done save in the rarest of rare cases when the alternative option is unquestionably foreclosed. Section 354 clause 3 mandates the court convicting a person for an offense punishable with death or in the alternative with imprisonment for life or imprisonment for a term of years, not to impose the death sentence on that person unless there are special reasons to be recorded for such sentences. Now, the basic judgment was that in 1980, the Supreme Court, by a majority of 4:1, reaffirmed its earlier decision and held that the provisions of death penalty as an alternative punishment for murder under Section 302 insofar is neither unreasonable nor it is against the public interest. It violates neither the letter nor the ethos of Article 19 of the Constitution of India. It is constitutionally valid. Exercise of discretion under Section 354 Clause 3 of CRPC 1973 should be in exceptional and grave circumstances, and imposition of death sentence should only be in the rarest of rare cases. Thank you so much.